pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
My bitch a choosy lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes get the most, not the lesser. Trash like the buck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm pulling business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side. If you know what I mean, I show you shit you never seen. The 7 wonders of the world. And I can make you the 8th if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker to walk a green mile. You piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rockin' what you say, well, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get chose.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Hi, everybody. Oh, I'm gonna piss you off. I'm gonna piss you guys off. Alexa, turn on the sign. Yeah, I'm gonna upset all of you with Alexa. Yeah. Hi. Yeah, I was not expecting. Well, I should have expected that I was going to be at the office late today. It was our deadline. I had a lot of work. I still got more to do tomorrow, but I'm finally here. We're gonna take a brief break. From the Slav sits. Watch it and get an interesting look at the concept known as judicial estoppel. And it's going to involve a defendant who, well, the prosecution is going to claim that the defendant's motion should not be approved under the common law doctrine of judicial estoppel. We're going to take a look at that today. I'm still like getting my bearings here. There you go. There we go. Judicial strudel? No. Judicial estoppel. No, not Gestapo. Estoppel. I don't know if you guys have oh my gosh, I've drawn a blank as to her name. I've seen this judge before and she's pretty good. Moore versus Alliance Credit Union. I haven't heard about that, Sathiel, honestly.
All right, we will go on
Let's
the
hear it.
record in the matters 24 CF 62, 24 CF 91, 24 CF 101, State of Wisconsin versus Justin Starkey. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Starkey appears in person in custody with counsel Glenn
Mogan.
Keene.
Thank you.
We're set here today in this matter for a competency hearing. Mr. Keene, is this matter proceeding? Have you been able to speak with Mr. Starkey?
Yes, I have, and on advice of counsel, he is wishing to stand mute today.
All right, he wishes to stand mute pursuant to Wisconsin statute 971.14 paren 4, paren B, he has the ability to stand mute. And I believe if the defendant stands mute or claims he is incompetent, the defendant shall be found incompetent unless the state proves by a greater weight of the credible evidence that the defendant is competent. All right, so therefore, Mr. Schmidt, you may proceed.
Before we do that, I'd like to make brief argument.
You may.
It's funny, this morning, Dr. Portner called me to make sure the hearing was still on. I indicated to him that I had thought the same thing. I had checked CCAP shortly before he called and saw that Mr. Starkey had gone to court in both Polk and Eau Claire and took the position. He was competent. He did not stand mute at those hearings, and the courts found him competent. I indicated to him that defense counsel had indicated to me he planned on saying he was not competent today. First words of Dr. Portner's mouth was, "Is he allowed to do that?" And I thought that was very sharp because Dr. Portner intuited, without being a lawyer, why judicial estoppel exists. It's to prevent people from playing games with the court, taking contradictory positions on the same issues in front of different courts.
So that's basically judicial estoppel. What the idea is that this defendant in other cases, in other counties, has declared to be competent to hear those cases. But now he's trying to claim that he's incompetent in this case. And these are cases that are simultaneously going forward. And not only that, you'll find out that he's going to declare himself competent and incompetent based on the same evaluation.
Mr. Starkey has had a Polk case for a very long time. It just recently resolved, and an Eau Claire case more recently, and then the 3 Burnett cases. He raised competency originally in Polk in October 23. He had Dr. Minter. Dr. Minter said he was competent. He agreed he was competent, took the position he was competent. Court found him competent. He then raised competency in Eau Claire and Polk around the same time in this year. If you recall, Judge, defense counsel didn't want to raise competency originally in this case because they wanted to see what happened in Polk and Eau Claire first. After the Polk competency hearing got moved for reasons we didn't know and wasn't rescheduled, we finally just set it for competency and scheduled ours. In the meantime, Mr. Starkey has gone to Eau Claire on August 26th, took the position he was competent based on the exact same report from Dr. Portner, and the court did find him competent. 3 weeks ago in Polk County, he appeared there. He was again agreed he was competent, took that position, and then was found competent. He's had a plea and sentencing in Polk County in the meantime. He's scheduled for an arraignment tomorrow in Eau Claire, where he's still taking the position he's competent. And now he's here today taking a different position. Judicial estoppel can be applied where it's the same issue in both cases. The issue in all the cases is competency. None of the fact patterns are complicated. They're all kind of samey charges. None of them involves complicated evidence like GPS or DNA or geofencing or anything like that. He's taken the position in the past 2 cases and prevailed on that position. The position he took was that he's competent. He didn't stand mute at those hearings. And the position he's taking today is different. I don't believe that. I believe he's playing fast and loose for calculated reasons, for strategic reasons. And I believe that he should be stopped from taking a position other than that. He's competent, as he did in Polk County and Eau Claire and continues to in Eau Claire. Thank you.
Thank you. Argument?
Yes, Your Honor. I would note that first, he did stand mute today, so he's not contradicting it. And as I know in my reply brief, and as the court is aware, in a competency, not only the defendant, but the defense attorney, the
Well,
prosecutor.
your reply brief that was filed this morning.
Yes.
I just was provided notice of 2 minutes before this hearing.
Yes, I understand. I was not saying that so you read the brief. I was just saying that, say that to point out that I know you're aware of the law is what I was getting at.
Okay.
I was not trying to say, yeah, I expect you to have read the argument. Okay.
Here we go.
Mr. Starkey this morning just stood mute. And my argument is that as a defense counsel, based upon my knowledge of facts in the case, I have an affirmative obligation to bring up competency. And if I fail to do so, I'm per se incompetent, and I find the statute in the brief I filed, but it's like State versus Johnson. So
Oh God, this is painful.
if I
This is really
don't challenge competency, I'm automatically, deemed to have provided ineffective assistance to counsel.
So what he's saying is that his hands are tied. He has to adhere to his client's wishes to raise a competency, even though he's aware of the situations in these other cases. Like, that's the long and short of it. He's like, my hands are tied. If I don't do this, I'll get docked for ineffective assistance to counsel.
Mr. Schmidt.
So that's half of the correct statement of the law. It's not only per se ineffective assistance counsel not to raise competency when you doubt it, but it's actually an ethics violation too. It's in the ethics rules. He has raised competency. Once you've raised it, you're supposed to take whatever position your defendant says. You could have a client who says they're Jesus Christ, and if they tell you, I want you to take the position I'm competent, if they say I'm competent, that's their decision to make. Then the attorney argues that. You don't go against their wishes at the competency hearing, and you do take their position at the competency hearing. That is clear law.
So if Mr. Starkey is standing mute or saying he's not competent today, but he said he was competent in Polk and Eau Claire, isn't Mr. Keene doing his job as an attorney and standing by his client?
Yes, what I'm getting at is this. I'm not saying Mr. Keene is doing anything wrong. I'm saying he can't use himself as a shield for Justin Starkey's decisions. Justin Starkey made the decision in Eau Claire and Polk to take the position he's competent, just as he's taking the position today to stand mute, knowing it was a different position.
So you're asking the court to take judicial notice of the Polk County case as well as the Eau Claire case, and the competency decisions and findings, as well as Mr. Starkey's admissions to competency in both of those cases, and then use judicial estoppel to find he is competent here today.
So, taking judicial notice is basically what the judge, the court is taking a certain set of facts as true for the purposes of the case. So, in other words, she will say, like, I want the court to take judicial notice of the outstanding cases, the defendant's statements in these cases, and rather than to like say like open challenges to it, to entertain open challenges to it. Like, okay, you gotta, can you prove that he said this? Can you prove that this case be heard? Most of the time, when they're taking the judicial notice, you provide like a case docket or something that can be verified. But also another case, this is a more simple explanation would be like, the court will take judicial notice that the weather today is thunderstorms. For whatever reason that the day's weather is relevant outside. It's like it's basically assuring that it also takes a judge can take judicial notice if a witness or defendant or the record will say like of a person's actions that they're not verbalizing because it wouldn't be necessarily be on the record.
What I'm asking the court to do is what's super important for judicial estoppel, what people are stopped into doing or out of doing is taking a different position. What I'm asking the court to find is that he took the position he was competent in both of those proceedings. He should be stopped into taking that position today, which makes this hearing really a summary hearing based upon the doctor's report.
We have the doctor. Might as well use the doctor. And then I will take the argument in advance. We have Dr. Portner here. I have his report. Mr. Schmidt, you may proceed. First, I'm
need
going to
a-
say, Dr. Portner, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you may begin.
Hi, could you state your name for the record?
Yeah, Matthew Portner.
What was your employment when you did these, when you did the assessment of Mr. Starkey?
So I'm no longer employed with the state of Wisconsin, but at the time I was a postdoctoral fellow at Mendota Mental Health Institute.
Oh, and were you asked to do some sort of assessment on Mr. Starkey?
Yes, I was asked to do a court-ordered competency evaluation.
What does that entail? What did you do?
Entails a thorough record review, although for this particular evaluation, because we are given a 15-day limit to complete the evaluation, I was not provided with substantial records, but for the records I had available, I reviewed those. It also includes observation and consultation with other members of the treatment team, how Mr. Starkey presented on the unit, his daily activities, group attendance, participation in those groups, the competency education groups of which I led. I had direct observation, as well as it culminates in a comprehensive competency evaluation conducted by myself.
So you and your staff did things together, basically.
That's correct.
So I'm going to start with your opinion and work backwards from there, if that's okay.
Yes.
So you ultimately came to an opinion that Mr. Starkey does not lack substantial mental capacity to understand the proceedings and assist in his defense. What was the basis for that?
The basis is that he was able to complete pretty much my entire interview. I did note that around minute 55 of about the hour-long interview, he made some tangential remarks. But the fact that he was able to answer my questions, the fact that he was able to show a factual knowledge, he was able to show rational appreciation based on my questioning, as well as he indicated that he was able to assist his defense counsel. That was the basis for my opinion. Even before at that minute 55 mark, he had made some remarks that were peculiar and unrelated to what we were discussing.
Was Mr. Starkey able to describe all the people in courts, the judge, the prosecutor, the defense attorney?
At least for the individuals that you just mentioned, yes, he was.
And was he able to describe their roles and what they do?
Yes, he was.
Did you try troubleshooting going through a charge and seeing if he could make decisions about it and recall it?
I did. Due to the extensive number of charges he was facing, I didn't go through every single charge. However, I picked one.
What the hell is this guy charged with?
Specifically, I picked one of the most serious charges, asked if he could identify that. He was also able to list specific details from that charge, including witnesses, the potential of people that could testify against him in that case. He gave a full description of the case that was consistent with the criminal complaint, as well as we utilized that case to go through potential plea options and other court-related matters.
Was he able to describe the plea options accurately?
Yes, he was.
There's mention in here that when he didn't know information, he would use his materials to reference it. Why was that of particular interest to you?
So it was interesting that I never tell defendants to bring materials with them. I let them make the decision to. They are provided several worksheets and as well as a competency workbook when they're admitted to the unit. And if they choose to, they can bring it. I never disallow them from bringing it to the evaluation. But certainly we want to get a good idea of whether they know the information first without referencing materials. And if they struggle with materials, then we allow them to reference anything they bring. So it was important that he brought that, not only because he did know some information without referencing any of his materials, but it shows some rational appreciation that he can bring the materials and he can reference them if he needs them.
So it shows that sort of rational thought is what it shows.
That's correct.
So some of the people on the unit had some thoughts about Mr. Starkey and his seizures. What were those?
I consulted with the medical staff, both the psychiatrist. I read documentation from the on-call psychiatrist as well as consulted with the nursing staff. And based on the fact that Mr. Starkey was prescribed anti-seizure medications prior to his admission, was continued on those medications, as well as from what the physicians observed, as well as nursing staff observed for these incidents that were described as seizure-like.
So it sounds like the doctor is making the assessment that he does seem to be competent, which would correlate with the other decisions that were made in the other cases.
Activity. They did not agree that they were indicative of seizure-like activity.
They believed he was malingering the symptoms.
I believe I used the word feigning, but yes, they did not state that they were true seizure-like activity.
Did any of the past competency reports you reviewed talk about Mr.
Faking seizures.
Starkey feigning or malingering?
There was one competency evaluation that I reviewed that mentioned the potential of malingering, but in that report, to the best of my knowledge, the evaluator was not able to complete any malingering assessment, so they weren't able to form an opinion on whether Mr. Starkey was malingering at that time.
Okay. I have no other questions then.
Mr. Kane?
Okay, yes, Dr. Portner. What do you understand if someone that you evaluate has to be aware of to be found competent, mentally competent to proceed?
To my knowledge, there are 3 basic prongs. They have to demonstrate factual knowledge, rational appreciation of plea options, as well as their understanding of their own case and charges, and they have to be able to assist their attorney.
Okay, so you said one was a rational understanding of their own case and charges. Did I hear you correctly?
Yes.
Okay. So in your report, you talk about in your interview that Mr. Starkey mentioned stolen identity and people committing crimes using his name. Was he talking about those in references to the charges he was facing in any of the counties?
I don't believe so. At the time, I redirected him because we were discussing his ability to assist his attorney. We had already gone through his charges at that point. So I redirected him and asked whether he felt that his attorney was doing a good job, to which he was able to redirect the conversation and answer appropriately.
Okay, but did he say that someone had stolen his identity and that's why he was in jail or something along those lines?
He did, I believe, mention something about a stolen identity. As to whether it was related to him being in jail, I'm not sure about that.
Okay, and did it also mentions something about someone stealing his word find puzzles? Would that be correct?
That would be correct.
Okay. So if an interview is focused on whether or not Mr. Starkey can rationally assist in his defense, would focusing on word find puzzles and stolen identity demonstrate a rational appreciation of the facts in his criminal cases that involve Mr. Starkey being arrested on a scene, Mr. Starkey being accused in one case by his mother, and Mr. Starkey in other cases that he's been charged with where he's in the custody of jail, so someone couldn't have his ID?
In those cases, I did write, following each of the phrases that you noted, the paranoid ideation, as well as someone stealing the word finding puzzles. The authors of those reports stated that this did not appear to affect his ability to discuss his charges or recent potential pleas in a self-serving manner.
Doctor, I have no further questions for you.
Additional redirect?
No.
All right, you may step down. You are released. Thank you, Dr. Portner. All right, argument, Mr. Schmidt.
The doctor's report clearly shows that Mr. Starkey's aware of the facts of this case. He can rationally deal with them. He has the foresight and thinking to bring his stuff with him, to reference it if he needs it. He knows who the actors are in court and what our roles are. The fact that he may or may not have delusions is irrelevant. Not every mentally ill person is not competent to stand trial. This isn't a Chapter 51. The standard is really, really low. It's understand the proceedings, know the facts, capable of learning the facts, rationalizing with the facts, helping your attorney. He's shown all that here. What's of particular concern is all the references to him malingering and feigning symptoms to try to seem worse than he is, in terms of the stroke, in terms of or the seizure strokes or whatever, and in terms of the delusions, only saying those around specific staff. I think he's obviously competent. It's what the doctor has. There's no medical testimony to contradict it. Thank you.
All right, Mr. Keene.
Well, first, just to note that again,
Oh, boy.
Dr. Portner's only role is to advise the court on the court's determination. It's not like a medical diagnosis where we're
Right.
asking the doctor to make the decision.
Uh-huh.
Regarding the concerns, one, whether or not he was faking seizures for whatever reason doesn't really bear on mental competency. Second, when I did ask the doctor during his testimony about if he was talking about word finds and someone named Andrew and stolen identity, the doctor was not able to find out whether or not that was just in general testimony, but it was triggered when he was being talked to about a specific cases. So the fact that he didn't choose to bring it up every single day or at other times to other staff doesn't indicate a faking of symptoms, because we don't know what he was asked by the staff. I mean, if he's asked, do you want Jell-O with your lunch? Talking about someone taking his word find puzzles probably would not be relevant. And there's nothing entered in the record to state that he was asked about similar topics, i.e. his criminal cases, and then chose not to bring those up because he, knew he wasn't around the doctor.
Again, I have heard the testimony of the doctor, and I have reviewed the report and received that as evidence. The report is quite clear, and the doctor's testimony is quite clear in the fact that Mr. Starkey does understand. He has a rational and reasonable understanding of his defense and his ability to assist in his defense. And the doctor is clear in the information and evidence provided that Mr. Starkey is malingering and feigning his symptoms and, quite honestly, pretending to be worse than he is with his symptoms. I believe that the state has proven this by the greater weight of credible evidence that Mr. Starkey is competent to proceed in this case and has met its burden. That is, if the court does proceed in a competency hearing. Now, we go to the judicial estoppel evidence. And quite honestly, I believe that the state went above and beyond and proven that
Yeah, a little
by
bit.
a mountain. Judicial estoppel is a legal document that will prevent a party from taking a position in court that is inconsistent from a previous position that a defendant took in a different legal proceeding. And the purpose of this document is to preserve the integrity of a judicial system and to prevent parties from being dishonest and gaining unfair advantage. And that's exactly what Mr. Starkey is trying to do. Exactly. He is facing serious legal proceedings in Polk County, in Eau Claire County, and in Burnett County. And he's doing exactly that. He admitted to competency in Polk County. And so he was sentenced. He was not only did he plea, but he was sentenced in Polk County. He admitted to his competency in Eau Claire County, and he is to be arraigned on those charges tomorrow in Eau Claire County. And now he wishes to fight, or he wished to fight the competency in Burnett County, and we're dealing with the exact same report, the exact same evaluation from the exact same doctor from all three counties, And he wished to stop and not use the report and to claim incompetency for this case. So if the court would have found and said the state met its burden for judicial estoppel, and I would have granted that motion. But for the fact I hate appeals issues, hate them, hate to be overturned. So I wanted to doubly ensure that I would not be overturned on an issue. So I sealed it all up and doubled it all up. And so I grant on the estoppel and I'm finding him competent. So both of those are done. So he's competent, the matter proceeds. And so, Mr. Keen, let's get to a status date. How long do you need to be able to look at everything and to try and get the matter
Well, Your Honor,
discussed?
we may end up asking for a, we may end up looking at a, insanity issue. So I have to figure out.
I wouldn't say, you can't say insanity.
Oh,
in
boy.
there.
Well, not
Not
guilty when it
guilty.
comes to competency, but,
NGI.
right, NGI, but yeah,
Not guilty
NGI.
of-
incompetent, insanity, yeah.
Mental defect.
Right, by mental
The prosecutor's like, oh, this would be juicy.
defect,
Sorry.
yes. All right, so you can look at that and you can try and go that route. But again, that is that's a bigger hurdle. Okay, so let's look at that. February 6th. Can you do 9 a.m.?
All right. Well, I think the prosecution, the state adequately or perfectly called out the defendant on his BS, and the judge, it's a no-brainer. Like it really is a no-brainer. But you also want to make sure that you have all your ducks in a row, and make sure that the record is full and clear, and that there are no avenues by which the defendant can weasel their way into being overturned on appeal. So I don't want to keep this going forever and ever. I do want to I'm probably going to go live again. Because I want to take a look at that one case that I think a lot of other people have looked at before that has released today. It looks, and I think it involves the same judge. I think it does, but it's wild. It's pretty wild from what I hear. So, I'm gonna end the stream and then reset it. And then we're gonna take a look at that one too. So you guys have a good evening. If I don't see you again, but if not, I'll see you guys in about 10 to 15 minutes. Okay. All right. Bye.